A CRA employee asked the Tax Court of Canada to tax him on employment income he said he was entitled to, but may not have received. The court said, no. This case is about the meaning of one word, received. It also shows what evidence a taxpayer needs when challenging a T4 and where the tax court's jurisdiction ends. This is Seunath versus His Majesty the King, a Tax Court of Canada decision released July 23, 2026. Daryl Seunath was hired by the CRA in January of 2003. Over the years, he worked as an auditor and an appeals officer. His annual salary for 2021 was set at $70,749. For that year, he reported total employment income of $43,613.58. About $3,450 came from work as a server. The remaining $40,163.97 was from his employment with the CRA. The appellant took medical leave at the beginning of 2021. He was placed on involuntary unpaid medical leave as of July 12th. His access to CRA computer systems was removed, and he could not work for the remainder of the year. He returned to work in May of 2023. The appellant said the amount attributed to his CRA employment was wrong, but he did not provide the court with what he said was the correct amount. At times, he asserted that he received more than assessed. At other times, he suggested that he may have received less. In closing submissions, he asked to be assessed using his full annual salary of $70,749. The appellant did not provide sufficient evidence that he actually received that amount in 2021. There was also a dispute about hours worked between May and June of 2021. The appellant said he was in training. His supervisors recoded the time as unauthorized leave without pay. He had already been paid for that period, and the CRA clawed back the amount in 2023. Taxation of employment income is set out in subsection 5(1) of the Income Tax Act. It provides that a taxpayer's income from an office or employment is the salary, wages, and other remuneration, including gratuities, received by the taxpayer in the year. The operative word is received. The court said that receive means to get, derive benefits from, or enjoy advantages from something. Employment income is determined using the cash method. The tax court does not determine how much an employee ought to be paid. Its jurisdiction in this appeal was to decide, as a question of fact, how much employment income the appellant received in 2021. Whether he was entitled to receive more was a matter for another forum. The appellant incorrectly asserted in his notice of appeal that the respondent carried the evidentiary burden. The onus was on the appellant to demonstrate that the amount reported on the T4 was incorrect. During cross-examination, he admitted that he did not have bank records or pay stubs establishing how much he received. Those records were within his power to produce, and he gave no explanation for not producing them. Instead, the appellant produced 3 records of employment, each showing a different amount. All 3 were around $20,000. The court said they were of little assistance in establishing how much he actually received, because he also admitted receiving a lump sum payment that the records did not include. The later clawback did not change the amount received in 2021. The court stated that repayment of employment income in a later year does not alter the salary received in the earlier year. A clawback affects the subsequent year in which it is made. The court described this as a unique case because the CRA was involved both as the agent responsible for the assessment and as the appellant's employer. Even so, the minister's conduct was not relevant to a matter within the tax court's jurisdiction. The appellant also sought declarations concerning his supervisors, damages, and amendments to his T4 slips. Those remedies were outside the tax court's jurisdiction. Its role was to determine the accuracy of the assessment, not the process by which the assessment was made. The court returned to the central question. How much did the appellant actually receive from the CRA in 2021? He did not provide evidence capable of establishing that amount. He He did not establish that he received either less or more than $40,163.97. The appeal was dismissed without costs. 3 practical takeaways. First, employment income is generally determined by what was received in the year. A disagreement about what an employer should have paid is a different question. Second, if you challenge employment income reported on a T4, records matter. Pay stubs, bank statements, and a reconciliation can show what actually moved. A belief that the slip is wrong is not enough. Third, the tax court decides whether a tax assessment is correct. It does not decide claims for employment damages or supervisor misconduct. This was an informal procedure appeal, decided on its own facts. Decisions turn on their own facts.